This is continuing coverage. The Black Swan murder trial of Ashley Benefield from the Hidden Killers podcast and True Crime Today. Now back to the courtroom.
All right, good morning, everybody. While you're getting settled in, we're back on the record in State of Florida versus Ashley Christina Benefield, 2020 CF 3014. It's Tuesday morning. We're getting ready to begin the first day of trial with preliminary instructions and opening statements, and then we'll start with the calling of witnesses. They're bringing the jury up right now. State, is there anything we need to cover before we bring them in?
No. Yes. It's not really. Sorry. I have the jury instructions for redactions and transcripts. I just have to find them, Judge, but they're.
I have both of those.
Okay, I wasn't sure. I prepared them in case you needed them. Thank you.
Anything before we bring the jury in?
Not before opening statements. I do want to alert the court that we want the opportunity to address Your Honor on some of the witnesses that the state intends to call this morning before they actually testify for some motions.
All right. So it would probably be better to do that now, I would think. Otherwise, I'm going to have to send the jury out. We'll have argument, then we'll call the witness. Then I send them out. Each time you're going to make argument.
Sure. Whatever the court's preference is. So, what we have worked out between the parties, Your Honor, is that we're going to provide the other side with a list of the witnesses that we respectively intend to call for the next day of trial. So pursuant to that informal agreement, we received yesterday a list by the state of several of the witnesses that they intend to call today. I don't know that it's in any particular order, but one of them is Tommy Benefield, another is Eva Benefield, and Alicia Benefield, Byers rather, and several others. And we have some concerns that we want to raise with the court before the witnesses actually testify, to everything ranging from relevance. For example, Your Honor, Eva Benefield, with all due respect to her having lost her father, we do not see anything that she has to say that is relevant to this inquiry. We took her deposition and we concluded that was clearly the case. As to a witness such as Tommy Benefield, his stand your ground testimony was rife with hearsay and information that he did not have personal knowledge of. And of course, we want to preclude that here in the trial. As to some of the witnesses, such as Alicia Byers and Barbara Russell, Your Honor, we believe that the state's intent on calling these witnesses is to go down the child abuse road. We are extremely concerned with that for several reasons, not the least of which is relevance. This is, after all, a homicide trial. We don't want to go down the rabbit hole of chasing whether or not this child was actually abused. We don't think it has any relevance. It's completely collateral to the charges that Ms. Benefield is on trial for. And most importantly, perhaps, under 403's analysis, we firmly believe and we fear. We don't know that it will inure to our detriment any more than it might inure to the state's detriment, but raising the issue of child abuse is going to confuse this jury. It's going to distract their attention from the ultimate issue for which we're here, which is whether or not this shooting was justified. We acknowledge that Ms. Benefield was responsible for the shooting. All that's left is it was either self-defense or it wasn't. And if we go down that rabbit hole, we fear that it's going to create issues in the minds of the jurors that they're going to wonder, for the same reason that Your Honor can including Kimberly Griffin, really have nothing relevant to add. The court, we believe, has staked out, if you will, the admissible parameters, that being specifically what law enforcement did as it relates to this. And they, indeed, we tend to call Deputy Moreland, for example, who was the deputy that accompanied the CPT team in some of these interviews. But we feel that if it gets into the substance of those statements, it's going to create problems for all of us.
The substance of what statements?
Of whether or not there was child abuse, allegations of child abuse. That was never resolved, Your Honor. And I might point out to the court, there were allegations of abuse because of various injuries that the child was returned with, and because of some of the behavior that the child exhibited. But those allegations were not confined to any one place. There were two professionals, a pediatrician as well as a psychologist, that were responsible for some of those allegations. We just don't see what possible relevance that could have, and when you balance the probative value of that against the danger of unfair prejudice, and again, I'm not sure which side the unfair prejudice is going to be directed at, because I think child abuse is going to raise the eyebrows of every one of those. Especially, we have 5 women on the media panel, and they may very well, it's kind of like the atomic bomb, they may very well feel that the state should have done more and hold it against them. I don't know that they will hold it against us. If they consider the validity of the allegations. And if they consider the validity of the allegations, Judge White, there we are. We're now litigating whether or not there was any truth and whether or not the child was actually abused. And I think it's going to be a mistake, respectfully.
Thank you. Do you have any response?
Judge, I do not intend to ask Barbara Russell or Alicia Byers about child abuse or anything like that. That is not why they're being called. So if that was the concern, then there should not be a concern. As for Eva Benefield, she is going to testify just about background, the tenor of this relationship when they first met and that type of thing, which I think is relevant. Also, Tommy Benefield, I recognize he testified to a lot in the stand your ground that may not be relevant at this point. So I have tailored my questions down to just what he saw in her.
All right. Final thoughts?
Yeah, the only thing I would say in response is, as to Eva Benefield, Your Honor, I think she's being called for the sympathy factor, having lost her father. There's nothing about the background and about her being in the house periodically that sheds any relevance on this. We took her deposition. She has no knowledge of any of the specific events. The only thing at best that she can say, and I think this is why the state's calling her, is going to be an effort to introduce inappropriate character evidence of Ms. Benefield. Eva Benefield relates in a couple of incidents in her deposition where Ashley Benefield and her mother, Alicia Byers, spoke with Eva and tried to tell her how dangerous her father was. And of course, being a young girl, or for that matter, just out of a sense of loyalty to her father, which is understandable, she was put off by that. And whether or not that is offered in an effort to portray Ashley Benefield and her mother, Alicia Byers, as mean or spiteful, would really be inappropriate character evidence. And we have not opened that door. And as the court well knows, that doesn't come in. It's inadmissible until such time as we do. So I don't see respectfully any relevance to that. Balanced against the sympathy factor, I don't think she's an appropriate witness, Your Honor.
All right, thank you both very much. Of the four names you mentioned, of course, Tommy Benefield testified at the Stand Your Ground hearing, and while I'm sure you both remember that I had a footnote where I mentioned that during the Stand Your Ground hearing, I allowed quite a bit in because as the court, I think I am capable of knowing what's admissible and what's relevant in making a legal determination. So I allowed a lot more in than I would allow in during this trial, and I hinted at that, or I think I actually stated it pretty expressly in one of my footnotes, that just because it came in at the Stand Your Ground hearing does not mean it's coming in at the trial, subject to appropriate objection. The only person that, of the four you mentioned, that testified at the Stand Your Ground hearing is Mr. Benefield, Tommy Benefield, and State, I just heard you acknowledge that you understand that a lot of his testimony, I'm not going to put a percentage on it, was allowed, but may not be admissible at trial. Eva Benefield did not testify. I don't know the substance of her testimony, what it's going to be. I've heard about a deposition that was taken, so I know you've had the opportunity to at least depose her and speak with her. Alicia Byers, so I had not even heard that name except reading it off of the witness list yesterday. So Alicia Byers is the defendant's mother.
Yes, sir.
And you're calling her,
Yes.
okay? And then, of course, I know Dr. Russell, we had the hearing with her. All I can say at this point is with kind of generic non-specifics. I don't feel like there's really any blanket ruling I can put on any of these particular witnesses. What I heard from the defense was hearsay as to Tommy Benefield. That may very well be the case to some of his testimony, lack of personal knowledge, whatever it might be. Eva Benefield is just a general relevance, and I don't know. I haven't even seen her deposition. I haven't had her at a pretrial hearing, so I don't know what her testimony is going to be. So at that point, I can just say object as you see fit. And Ms. Byers and Ms. Russell, I heard some of Ms. Russell's testimony at a prior hearing, but we didn't get into anything about child abuse or allegations of child abuse. And I have no idea what Ms. Byers is going to say. So all I can say is I'm not aware of a ruling I can make at this point, other than just to follow the rules of evidence. Before I bring the jury in, I did want to welcome everybody that's in the audience. Please check now to make sure that your cell phones are silent or off. There is no recording, audio or video in the courtroom. You can certainly speak with our media relations folks about how to get into the pool feed, or if you want to take pictures, we certainly have a media room where that can be done. There's not to be any cell phone use in the courtroom. I generally don't get too upset if people are they need to send or receive a text related to work or something like that. That's just fine, just as long as it's not distracting. So that allowance can very well change as the trial goes on. I'll also say with a group this size, it's not uncommon for people to need comfort breaks at various times throughout the case. I would ask if we could keep the in and out to a minimum. It can be distracting to the jury. And as I mentioned to the jury yesterday, I want them 100% focused on the testimony and evidence of this case. So if you can try and take your breaks, step out and come back in whenever we have a break between witnesses, maybe during bench conferences and so forth. I do appreciate it.
Judge, can I raise one other issue? I'm sorry, just as a prophylactic measure, reminding the court and the state of the agreement we have that there should be no reference to the Stand Your Ground hearing. It should instead be reference to just another hearing, and instruct our witnesses accordingly.
I think we should be clear on that.
Yes, and I instructed my witnesses on that.
Thank you.
All right, nobody's invoked the rule. Are we invoking the rule?
Yes. Actually, that raises one last issue, if I can. I think this has to be an ex parte conversation. Very brief ex parte conversation with the court.
Okay.
I just have one, just checking the evidence.
All right, the rule of sequestration has been invoked. If there are any witnesses who are present in the courtroom, you must leave at this point, as you cannot hear the testimony of other witnesses. You should not discuss your testimony or the questions asked of you with any other witnesses until such time as the court has released you from your subpoena or the trial is over and the jury has been discharged. You may talk to the attorneys, but not if other witnesses are present, and the attorneys cannot tell you what other witnesses have said in court. If you violate the rule of sequestration, you could face contempt proceedings, and if found in contempt of court, you could be ordered to pay a fine, serve time in jail, or both. Each attorney is responsible for advising their witnesses that the rule has been invoked and what this means. If you have a witness that prefers or needs to be instructed on the rule from the court, please advise me well in advance of their appearing so that instruction can occur outside the presence of the jury. I will add a caveat to my normal rule of sequestration admonition that I have been made aware that the case, the trial is online. I don't know if it's live as we're going or if it's just available online somewhere after the fact. But the rule of sequestration would also prevent witnesses from watching the trial live or watching a recording of the trial. If they're under subpoena, the rule applies to them. Please advise them of such.
And Judge, just to add on to that, we have Tommy Benefield and Eva Benefield. They will be the first two witnesses, and pursuant to Marcy's law, I would ask that they be allowed to sit in for the rest of the trial. They may be called as rebuttal witnesses. There's a slim chance, but that would only be if the defendant testifies. So if it pleases the court, if that happens and the defendant testifies, then we can ask them to step out for that testimony. But pursuant to Marcy's law, I believe they have a right to be here after they testify.
Do you want to be heard on that?
It's pretty timely, equal treatment. That's all I ask.
It's very timely.
Pursuant to Florida Statute 90.6162A D, as in Delta, a witness may not be excluded if the witness is, in a criminal case, the victim of the crime, the victim's next of kin, the parent or guardian of a minor child victim, or a lawful representative of such person, unless, upon motion, the court determines such presence to be prejudicial. Do you want to be heard on that? The last prong?
I think given the fact that they're both going to be called as witnesses, yes, I think it would be prejudicial.
State.
And Judge, that's why we're calling them first, so they can testify and get their main testimony out of the way before any of the other witnesses testify. And like I said, the only reason they would be called back is as rebuttal to if the defendant testifies. So I think we can solve the problem if the defendant chooses to testify, if we just remove them from the courtroom for that testimony.
All right, the rule is very specific. In a criminal case, the victim of the crime, the victim's next of kin, the parent or guardian of a minor child victim, or a lawful representative of such person. It's the disjunctive, not the conjunctive, so pick one. You can have the victim's next of kin or a lawful representative of such person. Pursuant to Marcy's law and pursuant to Rule 90.6162D, I don't find that one of their presences would be overly prejudicial. As we usually would, keep them in the back, and it shouldn't be a problem.
What is the statute the court cited?
90.6162A. And of course, if somebody's released from their subpoena, all right, that was a lot for not having any motions. You ready to go? State?
Yes.
Yes.
Defense. Okay. Let's bring the jury in.
That's right. Bring them together.
You all can have a seat. We stand for you. All right, you all can have a seat. Good morning, everybody. Welcome back. I see some of you brought your jackets and some layers to be comfortable in. So now you get to sit in the nice, comfortable seats as you listen to the testimony. As you notice, those seats do turn and swivel as you need to. I do have some initial instructions before we begin. I do want to ask, though, and again, you're going to get tired of hearing this from me because every time we separate and every time we come apart, I'm going to get some confirmation from you. So did anybody begin deliberations or talking about the case amongst yourselves? Did anybody talk about the case with anybody outside of this group? Or did anybody do any research on the people, places, things, or legal topics we've heard anything about?
Yes, sir.
All right, everybody says no. Thank you very much for honoring those very important traditions. Ladies and gentlemen of the jury, you have been selected and sworn as the jury to try the case of the state of Florida versus Ashley Christina Benefield. This is a criminal case. Ms. Benefield is charged with murder in the second degree with a firearm. The definition of this crime will be explained to you later. The state's charging document, which is called an information, is not evidence and is not to be considered by you as any proof of guilt. It is my responsibility to explain the law to you. It is your solemn responsibility to determine if the state has proved its accusations beyond a reasonable doubt against Ms. Benefield, in accordance with the law that I will give you at the end of the case. Thus, the province of the jury and the province of the court are well defined, and they do not overlap. This is one of the fundamental principles of our system of justice. Before proceeding further, it will be helpful if you understand how a trial is conducted. At the beginning of the trial, the attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the trial. What the lawyers say is not evidence, and you are not to consider it as evidence. Following the opening statements, witnesses will be called to testify under oath. They will be examined and cross-examined by the attorneys. Documents and other exhibits also may be produced as evidence. After the evidence has been presented, the court will give you the initial instructions on the law. The attorneys will then have an opportunity, if they wish, to make closing arguments to you. Following the closing arguments by the attorneys, the court will conclude by giving you the final jury instructions. After the final instructions are given, you will then retire to the jury room to consider your verdict. You should not form any definite or fixed opinion on the merits of the case until you have heard all of the evidence, the argument of the lawyer, and the instructions on the law by me. Until that time, you should not discuss the case amongst yourselves. Your verdict must be based solely on the evidence or the lack of evidence and the law. I now instruct you not to communicate with anyone, including your fellow jurors, about this case. No communication includes no emailing, text messaging, tweeting, blogging, or any other form of communication. Do not research about the case or look up any information about the case. If you become aware of any violation of any of these rules at all, notify court personnel, one of the deputies, or myself of that violation. During the trial, the court may take recesses and you will be permitted to go about your personal affairs. During these recesses, you must not discuss the case with anyone, nor permit anyone to say anything to you or in your presence about this case. If anyone attempts to say anything to you or in your presence about this case, tell him or her that you are on the jury trying the case and ask that person to stop. If he or she persists, leave that person at once, and you are to immediately report that matter to the court deputies who will advise me. You cannot use any cell phones, tablets, laptops, or other electronic devices in this courtroom. If you have an electronic device with you, please turn it off or silence it while we are in court. You may use these devices throughout the trial and during recesses, but even if then you may not use your cell phone or electronic device to find out any information about the case or communicate with anyone about the case or the people and places involved in the case. Do not take photographs, video recordings, or audio recordings of the proceedings or your fellow jurors. At the end of the case, while you are deliberating, you must not communicate with anyone outside of the jury room. If someone needs to contact you in an emergency, the court will receive messages and deliver them to you without delay. I previously gave you my business card, which has my judicial assistant's direct line. If someone needs to contact you in an emergency, my judicial assistant will notify the clerk or myself, and then we'll handle the situation as necessary. Was everybody able to give that information to whoever may need it? Yes. All right. If not, make sure you do so. This case must be tried by you only on the evidence presented during the trial, in your presence, and in the presence of the defendant, the attorneys, and myself. Jurors must not conduct any investigation of their own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any places or people discussed during the trial. Jurors must not have discussions of any sort with friends or family members about the case or the people and places involved in the case. Do not let even the closest family members make comments to you or ask questions about the trial. As I said yesterday, make me the bad guy and tell them you are under very strict orders from the court. You can't talk about it, you can't hear about it, you can't discuss it until this case is over and you're released from your obligations. In this age of electronic communication, I want to stress again that just as you must not talk about this case face to face, you must not talk about or communicate about this case using phones, computers, or other electronic devices. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. What are the reasons for these rules? These rules are imposed because jurors must decide the case without distraction and only on the evidence presented in this courtroom. If you investigate, research, or make inquiries on your own, I have no way to make sure that the information you obtain is proper for this case. Likewise, the parties have no opportunity to dispute or challenge the accuracy of what you find. This is contrary to our judicial system, which guarantees every party the right to ask questions about and challenge the evidence being considered against it, and to present argument with respect to that evidence. Any independent investigation by a juror unfairly and improperly prevents the parties from having these opportunities that our judicial system guarantees. Any juror who violates these restrictions jeopardizes the fairness of these proceedings, and a mistrial could result that would require the entire trial process to start over. A mistrial is a tremendous expense and inconvenience to the parties, the court, and the taxpayers. If you violate these rules, you may be held in contempt of court and face sanctions such as serving time in jail, paying a fine, or both. In every criminal proceeding, a defendant has the absolute right to remain silent. At no time is it the duty of a defendant to prove her innocence. From the exercise of a defendant's right to remain silent, a jury is not permitted to draw any inference of guilt, and the fact that a defendant did not take the witness stand must not influence your verdict in any manner whatsoever. The attorneys are trained in the rules of evidence and trial procedure, and it is their duty to make all objections they feel are proper. When an objection is made, you should not guess or speculate on the reason why it has been made. Likewise, if I sustain or uphold an objection, you must not guess or speculate on what might have occurred had the objection not been sustained, nor what a witness might have said had he or she been permitted to answer. During the trial, it may be necessary to confer with the attorneys out of your hearing to discuss matters that require consideration by me alone. It is impossible to predict when such a conference may be required or how long it will last. When such conferences occur, they will be conducted so as to consume as little of your time as is necessary for a fair and orderly trial of the case. Many times these conferences will occur at my bench, where the attorneys will approach, we'll have a conversation, and it'll be done. But sometimes the matters that we need to discuss more in depth, it's just much easier if I excuse you back to the jury room, the attorneys stay at their desk where they have all their materials, and we have more of a normal conversation. So either way that it happens, please rest assured that we will address those matters as quickly as possible in order to have that fair and orderly trial of the case. You are permitted to take notes during the trial, and you have been provided with a notepad and a pen for use to take those notes. Any notes that you take will be for your own personal use. However, you should not take them with you from the courtroom. During recesses, the court deputy will take possession of your notes and will return them to you when we reconvene. After you have completed all of your deliberations and you are discharged, the court deputy will deliver your notes to me. They will be destroyed. No one will ever read your notes. If you take notes, do not get so involved with note-taking that you become distracted from the proceedings. Your notes should only be used as aids to your memory. Whether or not you take notes, you should rely on your memory of the evidence, and you should not be unduly influenced by the notes of other jurors. Notes are not entitled to any greater weight than each juror's memory of the evidence. Before I go too far, I see you all have your pads. If you haven't already taken the cap off, test the pen. Just make sure it works. All right, everybody's good. Now, if you are a prodigious note taker like I am and you run out of paper, let us know. We've got boxes and boxes of paper for you if you need them. And if your pen starts running out, just hold it up, shake it for us, let us know. We'll get you another one. We got boxes of them. All right? Oh, also, I don't have them right here. If at any point during the trial you have a difficult time hearing someone, maybe it's soft-spoken, maybe they're far away, whatever it might be. If you have any difficulty hearing, just give one of the deputies the universal sign. Remember the old Carol Burnett? Anybody?
Yeah.
No? Okay, a couple. Give the universal sign and we can get you those headphones. Like I said, they're piped into all of these microphones and makes it really easy to hear. It'll help a lot. Also, some trials we have, there's quite a few observers. It's a public courtroom, and sometimes there's not a whole lot of observers. So there's going to be people going in and out of the courtroom throughout this trial. That's just fine. It can be distracting when that door opens a lot. I'm going to ask that you do everything you can to set aside those distractions and focus right here. This is the witness stand where the testimony is going to come from, and then of course the attorneys will be introducing and showing you any exhibits that are introduced into evidence. So the best you can, keep your focus. The attorneys will now have the opportunity to make an opening statement to you. Please remember that what the attorneys say is not evidence and should not be considered by you as evidence. However, it is important to listen as this is their chance to tell you what they believe the evidence will be in this case. State.
This case is about a woman who very early on in her pregnancy decided she wanted to be a single mother. And she did not want the father of this child to have any visitation, her husband. And everything she did from that point on was to attain that goal. And she would stop at nothing to attain that goal. She tried several things in the system that you'll hear. The courts, law enforcement, Department of Children and Families, no one got on her side. And at the end, when there was no other option, she shoots him and kills him and claims self-defense. Now this couple, Doug Benefield and Ashley Benefield, were married. They had moved to Florida from South Carolina. They lived together in South Carolina. Now when they lived down here in Florida in Bradenton, they did not live together. Obviously there were issues. Doug Benefield lived in his own apartment. Ashley Benefield lived with her mother, Alicia Byers, in a home with their daughter once she gave birth. She had this daughter who at the time was a toddler when she shot Doug. While they were living separate, they were still interacting with each other with the goal, the apparent goal, of seeking reconciliation, reconciling this family and becoming a family. They were going to restaurants, they were going to Selby Gardens, they were hanging out at the pool at Doug Benefield's apartment complex. By all images, they looked like they were trying to reconcile. The problem was, that is not what Ashley Benefield, although that's what she was portraying, that's not what she wanted. At the time that this shooting happened, they were planning to move to Maryland. Ashley's mother had inherited a home in Maryland and they were going to move to Maryland. Doug was also going to move to Maryland. They were going to continue to live separate and continue to attempt to reconcile, but they were all going to move to Maryland together. Excuse me. At the time that this happened, everybody was in moving mode. There were boxes everywhere, furniture, beds upended. They had a U-Haul that they were using together. They had a pod that was in the defendant's driveway that they were putting all of their things into. And every day around this time, Doug Benefield was going to Ashley's home to assist her in putting these things into the pod, putting these things into the U-Haul, because the plan was that they were all going to pack up in the next few days and move to Maryland. And it continued to try and work on their relationship. The problem was Ashley Benefield knew that this was a ruse. She didn't intend to reconcile. She didn't intend to try to make this work. And the problem was there was a court hearing on September 30th of 2020. And at that court hearing, all of this was going to come out. It was going to come out that she was acting one way when she was by herself, and she was acting another way when she was with Doug Benefield. That she was telling him she wanted to work on things, that she wanted to get this marriage back together. But yet, when separate, she was saying she had absolutely no intention of reconciling, did not want him around, and did not want this to work. On the 30th of September, this was going to come out. On the 27th of September, she shoots him and kills him. 3 days before this hearing and 3 days before this information was to become public. Now, there was no one else at the house at the time of the shooting. It was just Doug and Ashley. While Ashley's mother and child lived there, they had gone to the park. As soon as Doug got to the house, Alicia Byers takes her granddaughter and they go to the park. So the only people at the house are the defendant and the victim. And you're going to hear three very important things about this shooting. Number one, Ashley Benefield was the only person that was armed. It was her gun. She had it from before. It's not like she took it away from Doug. It was her gun. And Doug Benefield was not armed. He had no gun, no knife, no club, no weapon of any kind. Number two, Ashley Benefield was not in. Law enforcement took pictures of her right after the shooting. And then again, you'll hear in a few days, they took more pictures. Because sometimes law enforcement, they know that bruises sometimes don't show up right away, that it takes several days for these bruises to show up. So they took pictures several days later. And you'll see those pictures and you'll see that Ashley Benefield is not injured. She has some very superficial scratches on her midsection. Who knows where they came from? She had cats in the house. Who knows? But this is the only injury to her. And the third thing is the trajectory of the fatal bullet. Now, he was shot multiple times, but one of the bullets was fatal. The trajectory of that bullet was side. It was not straight on. Doug Benefield was not facing her, coming at her at the time that the fatal shot was fired. Now, as you go through this trial, it's a lot of information, a lot of timeline, but it's all very important to understand the tenor of this relationship between these two people. And it goes all the way back to when they met, back in 2016. That was the end of August 2016, they meet. They were both involved in some political event, and they met. 13 days later, they married. Doug Benefield was 54 years old. Ashley Benefield was 24 years. So there was a 30-year age gap between the two of them. They knew each other 13 days, and they got married. Ashley Benefield was very into the ballet, had been an ex-dancer. Her dream was to start a ballet company. And lo and behold, her husband has the money and the connection to get this done. So he begins and she begins to put this ballet company together. And they do put a ballet company together. But before it can actually take off, it falls apart. Before they're married even a whole year, so in April of 2017, Doug Benefield has his vasectomy reversed because they want a child. Within weeks or months of the vasectomy reversal, the defendant is pregnant. So all within a year of being married, they have done a vasectomy reversal, gotten pregnant, started a ballet, and the ballet has crumbled. While Ashley is pregnant, she decides she's too sick from the pregnancy, morning sickness, and that she needs her mother to take care of her. Her mother's in Florida, in Bradenton, Florida. So during her pregnancy, she moves to Bradenton, Florida to live with her mother so her mother can take care of her during the sickness. The two never lived together again. This was the last time these two lived together. They continued a long-distance relationship when she first moved to Florida and continued trying to keep it together in communication. But about the same time as the ballet collapses, right about all of this time, Ashley Benefield starts complaints against the victim. Her complaints are things like, the main one was that Doug Benefield was poisoning her with heavy metals, and her unborn child was being poisoned, that there was poison in her teeth, that he was giving her poison. There were also other complaints, domestic violence complaints, different types of complaints, but not once will you hear that she ever said he hit her. Not once did she ever say he choked her, kicked her, anything like that. Even though she's making these complaints, the victim, Doug Benefield, is still trying to make this work. And you're going to see some text messages and hear some things. He's still trying to make this work. But she is having none of it. So at about the time that she's ready to give birth, Doug Benefield contacts an attorney here in Florida, Sarasota, Florida, Stephanie Murphy, and asks her to help him write a letter to her, to Ashley Benefield, to state that he wants to be a part of the birth and he wants to be a part of this child's life and to please keep in contact with him. Ashley never answers that letter. That letter is sent via email on March 15th of 2018, which was several weeks early. She wasn't due yet. And the next day, she is induced. Her pregnancy is induced, and she gives birth to a daughter. She never tells Doug. He doesn't even know his child is born for weeks, and she never responds to the letter. The way that Doug knows that this child is born is that Ashley Benefield starts filing complaints again. And based on these complaints, he figures out, oh, my child's born, and now we have more complaints. The complaints revolved around the poisoning and the things that I talked about earlier. And she filed for what's called a violation of injunction, she filed for an injunction. An injunction is our legal way of saying restraining order. So when someone wants a restraining order, they have to go through a process and go to court, and the court has to decide, and you get a restraining order. So that was her process. She was trying to get a restraining order against Doug, and the allegations were what I said to you. At the same time, Doug Benefield had not seen his child, had not met his child. So he did a cross complaint to say, please let me have contact with my child. I've never even met my child. So this was set for a hearing, and it ended up going 2 days. It was long. It was a long process, a lot of witnesses in family court, and it ended up going 2 days. It began in July 30th, 2018, and it finished on September 17th, 2018. And at the conclusion of that hearing, the judge said, no, you are not getting a restraining order, and no, you cannot keep this man away from his child, and granted Doug Benefield immediate visitation with his daughter. He met his daughter for the first time. She was 6 months old. And at the time when they were exchanging custody, which was at the sheriff's office for meeting the child, all of this animus had been going on. I mean, they had just had these hearings and all of this. And at that first time sharing, that's what they call it nowadays in family courts, time sharing. At the first time sharing, Ashley starts becoming very nice to Doug and says, basically, I'll go with you for the visitation. And that's what they do. The family goes off for visitation. And that begins approximately a year, of basically them working on the relationship, going out to restaurants, doing things, hanging out together as a family. About a year. Now, Doug never moves in with Ashley. He keeps a separate residence. But after August of 2010, Ashley just stops talking to him. And that time, Doug files is that the defendant started off with 5 different complaints, all revolving not around her this time, but about the child. Because that's visitation with the child. So now these abusing the child. Are that Doug's abusing the child. What you'll hear is that not one of these charges was ever processed. Not one of these ever left law enforcement. And now has tried these 5 after Doug filed for a divorce. Law enforcement's not helping her see this still visitation going. And in the meeting of all these people, going to feel a logical evaluation. So they go to Doctor, and Dr. Broder does a very extensive evaluation. He meets with the child. She's a little girl, and at the time of the she's about not yet 2 years old. During this evaluation, and what you'll hear from Dr. Broder, is that Ashley Benefield acted very different when she was with Doug and when she was not with Doug. When she was with Doug, it was, we're moving to Maryland, we're going to work on our relationship and try and make this family work. When she's not with Doug, she's saying, no, how I do not want that. I want to reconcile with him. And to Doug's knowledge, all he's hearing is, I want to reconcile. So that's what he knows. Was coming out during 30th. September 30th, 2020, Ashley knew the ruse was up. Now, there had to be a request from both sides, the husband and the wife, this psychological report. And at one point before the hearing, Ashley Benefield tried to get Doug to drop that so the report would not get out, would not be released. Doug refused. So that report was coming out on the 30th, and on the 27th, kills him and claims self-defense. Now, you're probably going to hear a lot of information about Doug Bennett. Probably some negative things, not so nice things. I would just ask you to remember who and why. Just because someone speaks words does not make it true. So use your common sense as you go through this trial. This is a long story with a lot of information, but you'll see that this was a custody battle that this mother was going to win at all costs. And the cost was the life of Doug Bennett, and that is murder. Thank you.
Mr. Taylor.
Judge Wright, may I request the clerk to put the screen down? This is the divide between generations. I'm in the old school. I'd like to know that I have a picture and it's reliable. This is the new world. We rely on technology. I'm not sure that I'm a fan. All right, here we go. Good morning, ladies and gentlemen. This is Douglas Benefield. He was 58 when Ashley Benefield was forced to shoot him. Can I see the second picture, please? I want you to note how he's built for a 58-year-old man. Now, despite being raised by a family who taught me that it was ill to speak about the dead in an unflattering sense, I'm going to have some strong words about Douglas Benefield, the alleged victim in this case. I say alleged victim because he was anything but that. The evidence is going to show that Douglas Benefield was a very disturbed man. Of that, I assure you, you'll have no doubt when the case is over. 30 years older than Ashley, he was obsessed with her, and he successfully portrayed himself as everything he was not in an effort to win her hand in marriage. Despite promoting himself as a religious and decent human being, Doug Benefield was a manipulative, cunning, and abusive man, absolutely insisted on control. Among other things, you're going to learn during this trial that over the course of this 4-year relationship, Douglas Benefield did the following. He fired a handgun into the ceiling of their kitchen on an occasion to stop Ashley from talking. He threw a loaded gun at Ashley. He punched Doug in the face so hard that he knocked the dog unconscious. He regularly carried a concealed firearm that was racked, meaning pulled back and ready to fire. He unlawfully placed a tracker on Ashley Benefield's vehicle. He was regularly observed following Ashley Benefield in her car driving in Manatee and Sarasota counties, despite the fact that he was living in South Carolina, having driven all the way just to tail her. He was caught by a neighbor at night standing in the neighbor's backyard in an effort to peer into Ashley's house. He punched numerous holes in the drywall of their home when they lived together in South Carolina, and he had a previous marital history of domestic violence. Ashley Benefield was painfully aware of all of this on September 27, 2020, the day of the homicide. And I want to assure you that this is not going to come to you from just one place. These are acts that were admitted by Douglas Benefield himself. Ashley Benefield feared him. That was no secret, ladies and gentlemen. She left him a letter when she moved out 3 years prior to the homicide, detailing how scared she was of him because of all of these acts. She feared for herself and for her unborn child. 3 years before the shooting. She left him, he pursued her. She rejected him. He would not take no for an answer. She at times despised him. He did not care. She moved to get away from him. He followed her. She decided to go to Maryland. Surprise. He decided to go to Maryland as well. She belonged to him. He had the right to be with her, and no less than God decided that to be the case. Doug Benefield viewed Ashley Benefield as his property. Abusers seek to control their victims, to dominate them. At times, the pressure that Doug Benefield exerted and brought to bear upon Ashley Benefield was so overwhelming that it sometimes triggered questionable suspicions in Ashley's dedicated effort to protect herself and her child. Domestic violence victims have several things in common. Number one,
Overruled.
Number one, they initially believe things will get better. Instead, they get worse. Number two, domestic violence victims develop a get-along, go-along attitude. It's the mentality because appeasement keeps the beast at bay. Just do what he wants and you'll be safe. These domestic violence victims constantly speak about walking on eggshells. And the reason they describe it like that is for fear of anything that they say may trigger a reprisal by the abuser. And if children are involved, everything is magnified. They become hyper-vigilant. Ashley Benefield developed all of those characteristics. So on 9/27/2020, the day of the homicide, Doug arrives at the residence of Ashley Benefield. And as you heard, they are living separately. He does not live there. He never resided there. This is at her home in Bradenton. He had no claim for entering that home on that day except with the permission of Ashley, which she gave on that day because she was moving to Maryland and Doug was going to Maryland as well. But he knew, make no mistake, as the prosecutors told you, Doug Benefield knew full well on that day that this relationship was over. They were not going to be living together. Maybe, hopefully, they could work out some type of co-parenting agreement, but she was done. So how does that day's events unfold? What happens that results in us all assembling here this morning? It starts, ladies and gentlemen, with Doug Benefield once again seeking control. He is simmering when he arrives at Ashley's home on that morning, that afternoon. Why is he simmering? He's on a slow boil, actually, because he knows that Ashley's moving. He knows that this relationship is over. And immediately there's a discussion about how they should pack the belongings, with Ashley taking the position that her belongings should be packed last. Why? Because Ashley's things are going to be unloaded first, and Doug will then continue on to wherever it is that he was going to reside. So this is the most vulnerable time for a domestic violence victim, when the abuser recognizes that he's about to lose her. So what's his response to this? All right. Classic tactics of an abuser, they are threats and intimidation. On this afternoon, as the two of them are trying to pack this U-Haul in this pod, in an effort to avoid confrontation with him, Ashley says, after a short while, gee, you know, I'm really pretty exhausted. Why don't we stop for the day? We can finish tomorrow. Doug ignores it. His response is to grow increasingly aggressive and hostile. Not once, but twice, Doug body checks Ashley. And by body check, I mean he passes her in a hallway, slams his shoulder into her shoulder, almost knocking her over. That's not enough. The next thing is, as they're passing in a hallway, he's carrying a cardboard box. He jams the cardboard box into Ashley's side, which leaves scratches that the police photographer took. Again, now fearing for her safety because she sees how he is escalating in his behavior, she tries to persuade him, look, let's finish for the day. It's getting late. I'm tired. No go. Instead, Doug bellows, I know what you're doing. You're trying to get me to leave. I'm your husband, and I can spend the night if I want to. Well, that was enough for Ashley. She heads for the front door of the house to leave. Doug chases up to her, grabs her by the arm or hand, and spins her around so that his back is to the front door, blocking her from leaving. And he yells right in her face, where do you think you're going? Ashley, desperate at this point, Doug yells, you can't leave me. Ashley somehow finds the strength to summon up the nerve to say, I am done. You need to leave now. She commands him to leave the home. Terrified, while in his grasp, because he spun her around, his response is to smack her upside the head. And you'll see the pictures of her swollen face and her eye. And he yells, I am not done. Fearing for her life, as this was the first time that he had actually struck her. Up till then, it was always threats and intimidation. As intimidating as firing a gun may be to get you to stop speaking, he had never actually hit her. He'd pushed her. This time he struck her. Terrified after this, fearing for her life, she heads for her bedroom where she has a firearm. She gets to the firearm. She turns around. She orders Doug to stop. When she looks up, he's in the doorway. Instead of seeing the gun and leaving, Doug gets into this warrior pose with his arms moving purposely and advances. At that point, petrified, she fires, believing that if he gets a hold of her, she will be either seriously injured or killed. To her horror, after firing, he continues to advance. She absolutely panics. She tries to get away and backs to the side to create more distance between them, but there is no place left for her to go in this small bedroom. At that point, in utter panic, she keeps firing the gun. She sees Doug's legs go up in the air, almost as if he was running and slipped, and he falls backwards. Instinctively, she flees the house, and heads next door to John Sant's house. He's a neighbor. When all is said and done, ladies and gentlemen, and the testimony and the evidence is complete, the only thing that's going to have been established here beyond a reasonable doubt is that Douglas Benefield was a violent abuser. Ashley Benefield's efforts to placate him was absolutely consistent with what abused women do, especially when a child is involved, and that Ashley's result and resource to deadly force was absolutely justified under the circumstances. Thank you.
All right, thank you, Mr. Taylor.
Judge, can we approach?
Yes. Are we done for this, for the presentation for now?
Yes.
Yes.
More continuing coverage is on the way. The Black Swan murder trial of Ashley Benefield from the Hidden Killers podcast and True Crime Today. Press subscribe now.